The federal government introduced a Get Tough crackdown on repeat criminals today. It's making it tougher for people accused of violent crime to get out of jail on bail if they have a criminal history. The government introduced a series of changes today in response to what critics have been calling a catch-and-release bail system. Al Sweeney joins us live in studio with more. Al.
Taz, Ontario and other provinces have been demanding these changes for months. And one of the main events leading to the calls for change was a tragedy right here in our area that shook the community and police forces. Just after Christmas last year, OPP Constable Greg Pierce-Challa was shot and killed with no warning when he went to help after seeing a car in the ditch near Hagersville. One of the suspects charged with his murder, 25-year-old Randall McKenzie, was already facing charges for violent offences but was out on bail. The federal government introduced legislation today to keep that kind of thing from happening again.
An act to amend the criminal code, bail reform.
The government introduced a series of changes to the bail system.
Crucially, these proposed reforms signal that repeat violent offenders who pose a risk to community safety should not be released while awaiting trial.
Under the bail reform provisions, there's a new reverse-onus for some accused who are being held on criminal charges. Reverse-onus means the accused have to prove they should be released on bail, and not the prosecutor proving they should be kept in jail. It will apply to people charged with serious offenses involving violence and the use of a weapon, and who've been convicted of a similar offense within 5 years. Justice officials say bail would not automatically be denied, but it would be more difficult for the accused to get out on bail. And the court would have to say the safety and security of the community was considered when an accused was released on bail.
It requires courts to consider an accused person's history of convictions for violence, as well as community safety and security concerns when making a bail decision.
The provinces who run the courts were asking for these measures, hoping they'll make the streets safer.
On any given day, we have over 9,000 people in the Ontario correction system. And that means we have 9,000 people that are not on our street that could cause more of a problem.
But a prominent Hamilton criminal defense lawyer says the changes are a political reaction that could face a Charter of Rights challenge.
Bail rights in Canada it's settled law. It's long-standing settled law. And rightly so, because the presumption of innocence matters in our criminal justice system. And to say otherwise is frankly, it's offensive to criminal defense lawyers, but I think it should be offensive to the average Canadian.
So Colette says what would make a difference is giving police the resources to keep track of people who are out on bail. Now, reverse onus on bail is problematic in law since the person is accused of a crime but hasn't been convicted. Legally, they're innocent until proven guilty.